Hi everyone, this is James. I'm a senior associate at a IP specialist law firm named Allen in Hong Kong, and I'm also a Hong Kong qualified lawyer. Today I'm very happy to be here to be able to share with you a session on the must consider IP clauses. I believe the importance of this topic is because from a lot of different IP commercial disputes that we handle at our firm, a lot of the times the reason for those disputes are because the parties failed to or did not put in enough consideration into certain key IP clauses when they're drafting or when they're entering into various legal contracts, be it JV agreements, service agreements, franchise agreements, and basically any agreements that involves IP assets. So it's always better to avoid or try to mitigate or reduce the chances of these disputes arising in the first place by giving detailed and thorough consideration about certain IP issues and IP clauses before signing those contracts, so that everyone can avoid these painful disputes by the end. So before the session, I'll just quickly take this chance to introduce my firm. My firm is a full range IP specialist practice where we offer registration, prosecution, IP enforcement, IP litigation, and IP commercial work. We also do a lot of different advisory exercises for technology or data privacy related matters. In terms of regional presence, other than our Hong Kong office, we also do have an IP agency based in Beijing. We also have two sister firms in Kuala Lumpur and also Singapore. And in this year, we're also planning to launch our new legal office in Guangzhou as well. So we do have a very strong regional presence, and it really helps us to provide a more comprehensive IP legal services to our clients. Without going into too much detail, this page basically sets out most of the major awards and recognitions that our firm has received over the years for our IP specialties. As for myself, I mainly specialize in IP contentious matters as well as IP commercial matters. So I do handle quite a bit of anti-counterfeiting as well as litigation work, but also from time to time I would also advise on different IP related contracts. And as you can see on the right hand side, there's examples of some of the clients that I myself and the firm serve over the years. So without further delay, I would quickly start off today's presentation. Because I've only got 20 minutes, so due to the time constraints, I'll be focusing on 5 key IP clauses today. And as you can see, we want to talk about the importance of particularizing the IPs involved, also to deal with the parties' rights to legally deal with the IPs involved. Thirdly, there's also the scope and manner of use for the IPs involved in those transactions or agreements. And fourthly, warranties. And the fifth clause would be the post-termination arrangements for the IPs involved for these agreements. So when we're talking about particularizing the IP rights involved in commercial transactions, I think it's very important that we not only focus mainly just on the ones that we are familiar with, for example, the trademarks, patent, copyright, or registered designs, because from time to time we do have clients that may not be as aware that they also have other very valuable intangible assets that they can that they should also protect in the commercial agreements. And those are the ones that have actually been set out on the bottom right-hand corner of this slide. Namely, you can see the trade secrets or know-how or IP user guides. I think those are particularly valuable when it comes to various franchise agreements or JV agreements where certain party would be contributing all the know-how or all the experience or the skill sets that they have developed over the years on how best to utilize or commercialize or best apply their IPs, which is equally valuable information. Secondly, there's also a lot of different online intangible assets, for example, the domain names. Also the social media accounts, for example, the e-commerce accounts or the ones on Facebook or Instagram and so on. And I think lastly, some business may not be aware is also the importance of protecting or dealing with the goodwill, basically, in commercial transactions. So therefore, a lot of the times when our clients come to us for legal advice before entering into various different agreements, it's always an exercise that we would do is to go through all the different IPs or intangible assets the clients have, or at least, and also what the other side has as well, and to do a comprehensive list so that we know what type of IPs we are dealing with in these agreements. And usually in those agreements, after that exercise, especially agreements that are that the main subject matter would be the IPs, or that there will be a lot of different IPs involved in such a commercial transaction, we would strongly recommend that there is not only that there's a clause specifying the IPs that the agreement is dealing with, but we will also add some sort of a table or a schedule listing out the IP rights that the parties are dealing with or referring to. And not only that, it's also very important that there is either a separate clause or in the same clause that the parties would specify the ownership of these various IPs or intangible assets. And such a clause in terms of the ownership is important not only to talk about the existing IPs, for example, patent registrations or trademark registrations or copyrighted material, but it's also I think sometimes it's even more important to deal with the IPs that would be developed or created in the future cooperations. That is, sometimes what we call derivative IPs. And it's very important that at this stage that the parties set out clearly who would be the intended owner of these future IPs, because a lot of the times these IP disputes are to do with not mainly the IPs that already exist, but it's more the IPs that have been created after they enter into the agreement, and when they're created along the way of the performance of the agreement, and by the end the parties would have dispute as to actually who owns these IPs created thereafter. And in fact, there will actually be a few more slides after this slide where I would talk a little bit more about how to deal with various derivative IPs for different commercial transactions. Other than the ownership, a lot of the times the agreements basically would involve the licensing of various IPs, and it's important to set out clearly whether those IP licenses are royalty free, perpetual, irrevocable, transferable, or exclusive. So as I mentioned in the previous slide, nowadays a lot of IP disputes between contracting parties, especially those that concerns the ownership of certain IPs, would usually be the so-called derivative IPs, which means the IPs that are created kind of as a result of the performance of the agreement. And in certain industries or for certain products, derivative IPs, for example, modifications or improvements of certain technologies or IPs are basically inevitable. And for example, for computer programs, I mean, if for different users or licensees, when they have to use certain software or programs, they have to build on top of certain, they must build on top of those computer softwares in order to make them usable or to apply them to for their own business needs. But during the modification or improvements, arguably sometimes the user or licensee has created something new in terms of a new IP, and by that time the parties would usually have disputes as to who owned those newly created parts of IP. I mean, on one hand, the user or the licensee would be saying that, they are the ones who so-called invented these improved parts of the IP, but while the licensor or the original owner of the original part of the IP would argue that no, the right to modify belongs to them, and basically without the technology, the licensee wouldn't be able to create these technologies or copyrighted work. And so a lot of the time it much depends on different circumstances or on what sort of IPs we're dealing with. But I think the main takeaway or the main solution really is to, in the first place, specify in the agreement who owns the derivative IPs. And so we always advise our clients when they're entering into these sort of service or these commercial agreements that they have to deal with whether or not the user or the licensee may actually modify or improve those IPs, and if they're allowed to do so, then they have to make it clear who own those IPs. And usually, to be honest, from our experience, there's usually less controversy if those derivative IPs would be owned by the original owner or the licensor, but then there will be circumstances where the licensor or the original owner would actually, in order to incentivize the licensee to make improvements to technology, they would sometimes compensate the licensee for modifying or improve their IP. So that would be a very helpful way to deal with this issue at the outset, instead of leaving it until it's too late and where they have to end up in a bitter dispute. Secondly, there should always be a clause in the commercial agreements to deal with the party's right to legally deal with the IPs involved. And for example, firstly, it would be whether another party has the right to register certain IPs on behalf of the original IP owner. Such a scenario would usually take place in some franchise or license arrangements that involves a cross-border element, where the local distributor or the local reseller would argue that for the benefit of the business or the operation that they have, most of the times without the express consent or knowledge of the franchisor or the IP right owner to locally register, let's say, their IPs or sometimes even their patents. And when the commercial relationship turns sour or for whatever reason, the agreement or the arrangement has to be terminated, a lot of the times the local distributor or the local user would claim that they own such registration as shown on in the local registry, and sometimes they would refuse to return such registered IPs to the original owner. So I think it's important that you have such a clause in such agreements in the first place to specify whether they have the right to do so, and in case of disputes, you can always refer back to the agreement and prove that either you have the right or the local or you have not the right to register such IPs on behalf of the original owner. Also, there's also the sub-licensing of IPs. And usually we would ask the original IP owner to seriously consider imposing certain controls to make sure that the sub-licensing of the IPs do not go out of hand. For example, any sub-licensing of the IPs would require the owner's ultimate approval, or that they are only allowed to sub-license it once. They cannot allow the sub-licensee to further sub-license such IP rights to other parties. And also they should consider whether they should add a requirement that the local user or the local licensee needs to make sure that the sub-licensee would adhere to the IP obligations that have been set out in the original agreement. And lastly, I think most of the time we'll also advise the IP right owner to insist or to set out or to keep reserve the right to always audit the work of the sub-licensees to ensure that they have at least certain control of how their IPs are being used by the sub-licensees. Thirdly, the agreement should also deal with whether the licensee has the right to assign certain IPs, and usually the answer should be no. And lastly, for certain countries, there would be an obligation to arrange recordation for certain IP licensing arrangements, and so it's important to specify that the local company has the obligation not only to arrange the recordation, but when the arrangement ends or terminates, that they would need to, in good time, withdraw or cancel such recordation. Thirdly, of course, it's definitely important to spell out what is the scope and manner of use of the IPs involved. In terms of scope, usually we'll be talking about in terms of the jurisdictions, which territories or the goods, services, or mediums on which the IP are used. And I also, I always emphasize that it will be important to insert a certain wording somewhere in the agreement to say that the IP rights should only be used strictly for the purpose of performing this agreement only, so as to avoid any surprises, from any unexpected or unanticipated or unauthorized so-called use of the IPs by the other party. I think the IP right owner should also consider what sort of guidelines or limitations they would want to add into these commercial agreements to govern or to control how the other party would use their IPs, and a lot of the times I think it will be very useful to at least add a simple clause where it says that the IP owner has the final say, or at any time the IP owner would have the right to revoke or limit or modify the way that the licensee would use their IP rights, so as a sort of a safety net clause in that commercial arrangement. Fourthly, we come to the IP warranties. I think for IP warranties, I think it mainly concerns the assignees or the users or the licensees of IPs more than the original owner, because usually they're just some sort of assurance from the owner in terms of the legitimacy of the IP rights involved in those commercial arrangements or transactions. And the warranties usually would go as far as the owner giving warranty that they are the legitimate owner of those IP rights and that they are infringement free, that they're not copied from other right owners, and thirdly that the duration of these IP rights are not shorter than the agreement period. And basically the effect of these warranties is that if the owner is found to have breached those warranties, then the other party would be able to claim damages for all those damages that they suffered as a result of that breach. Lastly, I want to talk about the post-termination or termination clause that handles the IP rights involved in these commercial transactions. And I always say that this is definitely one of the more important IP clauses, because usually, I mean, a lot of the times when the parties have disputes or the relationship is not working very well, that they would choose to terminate the commercial agreement, and usually things are a little bit messy at that stage, and to at that end try and conclude the whole relationship neatly, and and get back all your IP rights, or to prevent the other party from using or dealing with your IP rights in a negative manner, is one of the top priorities really for the party. So the following terms or obligations I would always advise our client to consider adding or negotiating in these agreements. So let's say firstly, I think it's always important to add in an obligation for the parties to return or to destroy all confidential documents and trade secrets back to their original owner, or to just to destroy them. And which brings us to the second point, where it's important that the parties also agree to a non-disclosure clause, that all these confidential documents or all these trade secrets should not be disclosed to other third parties, which would definitely damage our client. I think thirdly, it's also important to make it clear that the other party may no longer, or they should immediately stop using our client's IPs once the agreement has been terminated. And if the other side has registered any IPs on behalf of the client, or let's say other domain names or e-commerce accounts or social media accounts, that all these intangible assets and IP registrations should all be assigned, duly assigned back to the original IP owner. And lastly, as a compliance requirement, it will be also important to make sure the the local distributor or the local user of the IP right would duly cancel the license recordation in good time. So this brings us to the end of today's presentation. I hope you all find it useful, and if you've got any questions, please feel free to ask me, and I'll try my best to address any questions that you may have. So thank you very much.